Good morning, Your Honors. I'm Steve Libby. I've tried cases in front of each one of y'all. In this case, I represent the appellant, Ann Hatley. I'd ask for 3 minutes of rebuttal, please.
3 minutes. All right, sir. You may proceed.
Thank you, Your Honor. Basically, this was a divorce trial. It's quite contested. It was tried in front of Chancellor Kyle. We had a lot of problems getting it to trial because Chancellor Kyle actually continued it like 3 different times sua sponte. After finally bringing a joint motion asking it to be transferred, he said he would try it, and he did. After a 3-day trial, he issued his ruling. We take issue with many of the issues in his ruling and ask for the following relief on the following issues, or asking for relief on the following issues. Alimony, I think as the proof, or as my argument hopefully shows, he used an improper analysis in reviewing the alimony issue. He denied alimony in futuro, finding the wife had no need for rehabilitation. As the record will show, he never, ever looked at her earning capacity. He said she's willfully underemployed, but never looked at her earning capacity. And the statute absolutely mandates you have to look at somebody's earning capacity when you make a determination of whether they're capable of rehabilitation. Also on the alimony issue, as the proof will show, the judge did not sufficiently look at the husband's surplus. And we'll get into it. The biggest issue is the husband testified that every year for the rest of his life, he's going to have $5,288 of attorney's fees every month, or $63,000 a year, and therefore he can't pay alimony because he's going to have to dedicate that money to attorney's fees in the future. And the judge did not seem to appreciate that that money could be used to pay alimony. On the issue, we're also appealing attorney fees at trial, and there were 2 really large errors on this issue. The court denied, both sides asked for attorney's fees to be paid. The court denied paying attorney's fees to either, but it applied the wrong statute. Just clearly used a statute that is more for post-divorce matters as opposed to divorce matters. Also, as we'll go into it, he allowed the husband to pay $113,000 in attorney's fees. I think they argue that it's really like $85,000 out of marital funds, while my client was forced to pay all of her attorney's fees, which were $82,000, as opposed to their $113,000 out of separate funds. And I think the case law showed that's not appropriate. And then we have several requests for modifications to the final decree. I'll probably have to ask Your Honors to read the brief because I doubt I'll be able to get to all of the issues that we've raised. But again, we think the division of the debt was not appropriately done. Again, the statute is the same as alimony. Both of them require a court to look at someone's earning capacity, and the judge never did that in this case. We also maintain that the distribution was inequitable. Then there's some issues regarding child support and a Rule 59 motion, which again, it was very frustrating on this Rule 59 motion because Chancellor Kyle left the bench shortly after the final decree. We were left without a judge for months and months and months and months and months while Rule 59 motions were pending. And then we appointed, Jim Newsom came in, and Chancellor Newsom heard the Rule 59 motions. Of course, he can't really say what the judge intended. So he basically denied them and said these look like issues for the Court of Appeals, and we are here. With regard to the alimony, I'll tell you a few things that y'all already know, which is alimony in futuro is available when rehabilitation is not feasible. The main statute involved is 36.
Mr. Lemon, let me stop you just for
Sure.
a second. On the alimony issue, and I understand and appreciate what you're saying about, the different types of alimony, which I understand. Here, the alimony that was awarded is labeled as transitional.
Correct.
What was she transitioning to?
That's the thing. She hadn't worked for 20 years. Her last job was working at a film festival about 24 years ago. Her and her sister tried to flip houses. That wasn't successful. She has a philosophy degree from, not SMU, but somewhere in Texas, in Dallas, that she's never utilized. She's never had a job. She's never had a career, and the judge was giving her transitional alimony, which is only available if the person is already rehabilitated. And they just need a little bit of money to get them through the transition from single life to divorce. But she never had any income from employment. So I don't think how the judge got to transitional alimony, I don't think he properly analyzed the alimony in futuro issue, which again, 36.5.121 F1 says that the disadvantaged spouse, alimony in futuro is available when the disadvantaged spouse is unable to achieve with reasonable effort an earning capacity that will permit the spouse's standard of living after the divorce to be reasonably comparable to the way it was during the marriage or.
What was her earning capacity?
That's the problem. The court never made any analysis of the earning capacity issue. She has physical issues. She had a cervical fusion. She has physical limitations. She's never had a career. We maintain that maybe she could make part-time, minimum wage, but the judge never looked at that and just purely kind of jumped to saying he doesn't think the rehabilitation was necessary.
Was there any proof introduced on her earning capacity?
Yes. Well, number one, she has oil and gas royalties for her parents both passed away.
I think the court took that into consideration as a separate property and the income that came in as a result of that.
Correct. So assessed her with $4,000 a month, and we thought that was appropriate. We went through, that was a large part of the trial, was what her earning capacity, her actual revenues were. Then there's the issue of, does she have an earning capacity based on employment? The court found her to be willfully underemployed. Never did any type of earning capacity analysis.
Again, was there any proof introduced on that?
Yes, there was significant proof.
Okay, tell me what that was.
That she has a philosophy degree that she's never utilized, that she hadn't worked in 20 years, that she has physical ailments with her her lumbar fusion, that she says she's not aware of any job that she could do full-time. So she testified to that. That was never really looked at. But she went into the fact that, again, she's been a 25-year homemaker without having a job.
So, without belaboring the point, no vocational proof was introduced, no expert about anything like that?
There was no expert introduced, but we did introduce regarding, earning capacity. You look at their age, employment history. We introduced all of her employment history going back to the film festival that she did. Then she and her sister tried to flip houses like they do on TV.
Right. You just reviewed her history, work history.
Yes. And then we reviewed her physical limitations and her issues. And again, her husband even found the doctor to do the cervical fusion, and she smokes marijuana, which they love talking about frequently at night, which again, it's not appropriate or certainly not within the law in Tennessee, but the husband acknowledged she does it for pain, she does it to sleep, she has all kinds of physical issues in that regard. But the statute says the court shall consider the earning capacity of each parties. We have a really long final decree. It never mentions the word earning capacity whatsoever. Also, at the time of trial, husband was 51, wife was 56, 24-year married, 4 children. The time of trial, the husband was earning over $330,000. He was in the prime of his career, and the court said that he was a workaholic, and the wife helped advance his career. The wife, again, it was Texas A&M, that she got a philosophy degree in 1991, but never held a job. Been a full-time parent since then. Presently, a doctor has recommended another lumbar fusion surgery for her that she has decided that she doesn't want to get right now. She has restrictions of manual labor, extended standing and bending. And the trial court's findings were basically in one paragraph, paragraph 108. It said, the court finds rehabilitation is not necessary because wife has a college education, continues to receive income from oil and gas, she's willfully underemployed, and she's economically disadvantaged and needs assistance. So those were the only court's findings regarding whether rehabilitation was appropriate, and it never even ventured into looking at any of her age, work history, her ability to earn income, and there was proof introduced on those issues.
Well, I said I wasn't going to belabor the point, but you just said something that made me have to come back to it. You said the court found her to be willfully underemployed. Is the court required to find what her regular employment would be in that situation?
Yes.
Okay.
In fact, Ellis versus Ellis, Chancellor Golden decided that one. The wife even stated she had no intention of returning to work. And because the trial court failed to consider whether she could reasonably reenter the employment market and was capable of earning a reasonable income, it reversed it. Even though the wife said, I'm not going back to work. Because again, the standard is, can she return to the standard of living she had during the marriage or that the husband is enjoying post-divorce? Erdman versus Erdman, this court decided just last year, Chancellor Golden again, he said, in that case, the wife was responsible for the breakup of the marriage. She had 2 affairs. The trial court said she didn't need alimony, and the Court of Appeals said it's unclear how the trial court could come to the conclusion she has no need for support, because that sounds totally conclusory, because it didn't look at what her earning capacity was, and the court found that the evidence supports another finding with greater convincing effect. Williams versus Williams, a 2019 case that Judge Armstrong decided, that one also was looking at, the question was whether the wife was able to return to her standard living that she had prior to. Never looked at that, besides the fact that the court said, well, they didn't have an unusually high standard of living, but there wasn't much analysis on that. This court just decided Levy versus Levy not long ago, and again, that was reversed purely because the court's failure to determine the wife's earning capacity. That is a crucial determination, and that was never even addressed. But the court did say, with regard to her injuries, that it did not find that she was prevented from obtaining any gainful employment. Well, it concerned me because that's the standard of proof for a workers' compensation matter for somebody trying to get permanent total disability. That is not an issue or the appropriate standard in a divorce case. But these parties had what the court found was not an unusually high standard of living, a very nice lifestyle, nice neighborhood, they could afford cars, they had housekeepers and landscape professionals, but the lack of finding regarding the earning capacity is fatal to it. With regard to division of property, the statute requires the same thing. You have to make a determination of the party's earning capacity when you're dividing the assets and debts. That wasn't done. I see my time is short, so I guess I'm going to have a very quick rebuttal, but unless anybody has any more questions, I'll turn it over to Mr. Rice for the time being.
I see none. Thank you.
Thank you.
May it please the court, my name is Nick Rice and I represent the plaintiff and the appellee, Dr. Mark Hatley. I am solely a divorce and family law attorney. By the nature of the beast and the job that I do not always get to represent a good person. In this case, I did manage to represent both a good man, a good father, and a good husband. Opposing party, the wife, points to husband being a workaholic as a cause for the demise of the marriage. This work is at St. Jude trying to cure childhood cancer, which I believe to be an admirable cause to overwork in. Dr. Hatley does not deserve what has occurred. He has suffered abuse at the hands of his wife. He suffered wife's alienation of his children against him. And during the divorce, in particular, he suffered her attempts to ruin his life and career by filing unfounded and invalid claims with both the FBI, TBI, MPD Sex Crimes Unit, and DCS, alleging, among many things, and most reprehensibly, that he raped 2 of his own daughters. Then when she was unsuccessful at ruining his life and career, she has the audacity to say, "Give me more money because you've managed to hold on to your job." The right decision was made by the trial court in a very difficult divorce with a very difficult defendant. The record does support the trial court's decisions, and the decision should be upheld on appeal. I'll be addressing the issues raised by wife and defending the trial court's decision on all of those. When we get to the alimony, this is a classic he said, she said situation. It was only the parties testifying in their trial. And when we look at wife's appellant argument, it's look at my testimony and look at my arguments at trial. Likewise, we have the same thing coming out of husband. When we're up on appeal, we're saying, look at my testimony and arguments at trial. The good news for husband in this case is that the trial court found him and believed him in his proof and his arguments and ruled accordingly. In a factual issue such as alimony, an appeals court is disinclined to second-guess the trial court. Great deference is given to the trial court as to witness credibility on a factual issue such as alimony. And when the court reviews the evidence in a light most favorable to the trial court's decision, and the trial court ruling in line with husband's proof and argument, there's no basis for overturning the trial court.
Well, let me ask you a question about that.
Yes, ma'am.
In page 20 of the trial court's ruling, he refers to in the paragraph 100 is what I'm looking at, that her chronic back pain, et cetera, did not prevent her from resuming work as a house flipper during the marriage.
Yes, ma'am.
All right. I have some trouble justifying that with earlier in the final decree on page 10, paragraph E, I believe it's paragraph E, somewhere in that part, he refers to the house flipping job as questionable. So I'm having trouble justifying where, on the one hand, this is referred to as a questionable occupation, but then it seems to have been relied on as something that she can do in the future.
Yes, ma'am, and I don't have that in front of me, but I believe what he was referring to, understanding the caveat, I could be incorrect, but I believe it was her story about how she cannot continue in the house flipping, which he found to be questionable, because when we look at the proof, this back injury occurred well before she even did any of that house flipping. All right, so then her efforts after this back injury that at trial she now says debilitates her, no medical proof was actually introduced that she's not capable of doing that work, but she did testify too, in the process of house flipping, she did a lot of administrative work. So that was finding houses, negotiating prices, obtaining bank financing, dealing with lawyers and going through all the closing. Then, once the house was flipped, getting it on the market, negotiating the sales price, again, dealing with closing attorneys and all that kind of stuff, plus the manual labor that she did on those houses. She testified that she would do things such as painting, tile work, various labor. I think she did flooring on one of the houses, did landscaping and things like that. And then in addition to that, she then ran the crews for the manual labor that she didn't actually do herself.
Is there proof in the record that she actually made money doing this?
There's not proof that she made money. There's proof that she expended effort. Now, I do think that the business was ultimately mismanaged, and not every person that has the ability to work is an entrepreneur or can own their own business and actually do that business. But what they can do is they can take all of these efforts that we just covered and apply those into working for someone else that does know how to actually run a business. So she has the capability for an extreme amount of administrative work and manual labor. She would just need to be directed appropriately. And I don't think that the trial court, and this dovetails into, and I might be getting off of your Honor's question, but I think that goes to why there was nothing set on her earning capacity once finding that she was willfully unemployed, because she is able to do something. The court addressed her need in the alimony analysis and gave her an appropriate amount of money. And in that, if I can get back to the transitional, how the court went over this and then decided you've got enough money, and then with your willful underemployment, you then have even more, and with the additional disbursements that you get on gas and oil, you get even more. And I'll get to that briefly, unless Your Honor wants me to jump to it now.
Was
Yes,
there any
ma'am.
proof that the disbursement for oil and gas revenues was going to go up in the future?
There's proof that in the past it has continued to go up. We could not predict the future that it would continue to go up. There was also evidence in the past of additional disbursements and additional royalties that continued to come in, and it's replete in the record. It is all over the place as to how much money wife could get. She was not very cooperative in discovery. A lot of the information we got at the last minute, we put on, and it's in our brief. By the time we went to trial, we had the most recent year of information that wife had given, which was well over double what the court actually decided. But that was all we had at the time. And then wife cherry-picked a small portion of what was most recent and used that to show to the trial court as this is all that I'm going to be making. And that's when the trial court said she makes at least this. And I believe that was in paragraph 96 of the final decree. Wife receives at least $4,000, I believe, yes, $67 a month from her gas and oil. That would take note of all the additional disbursements. As to the award of transitional alimony versus wife's opinion that she should be given in futuro, Ellis versus Ellis cites the statutory preference for rehabilitative and transitional short-term alimony, but it lays out the steps of the analysis also very well. The court should first look to see if rehabilitation is feasible, then if not, look at transitional alimony and decide if that's appropriate, And then if transitional alimony is not appropriate, the court is to consider long-term alimony at that point. And that's exactly what the trial court did. The trial court found the rehabilitation is not feasible and then determined that transitional is appropriate.
How did the court find that?
I'm just basing it on the final decree that came out.
Okay, I'm
The court-
just curious as the analysis of, you've got, the court made these findings of fact, and so I'm assuming then wife testified that she has no plans to go to work. That'd be accurate?
Yes, sir.
Okay. So consequently, there's nothing to rehab to. Is that
Well,
essentially what
yes, sir, there's no additional training, no additional certification or anything like that that was mentioned. So there would be no rehabilitation.
So wife had zero plans of any vocation going forward?
Right. And we also pointed out in that, wife receives Pendolite alimony throughout the divorce without any action to increase her earning ability whatsoever, without doing anything to take care of her financial situation after the divorce. And she admitted that she does not work and is not working, not because of a back injury, but because it is more fun not to work, to stay home, and to smoke marijuana daily. That was her testimony, and that's what she said.
Well, let me pose you a hypothetical question here. Assuming that the trial court's failure to establish an earning capacity for the wife is a problem, and the courts also found that the wife was willfully underemployed, and that obviously that makes one think she could make more money than what she is making. What is it that we are to look to if this court, based upon the evidence in the record, has to establish what her earning capacity is?
Well, it's, I believe Egan versus Egan says that appellate courts have not required trial courts to find a specific amount of need in every instance.
We're not
So
talking
I
about need,
don't-
we're talking about earning capacity here.
And I think the two are interrelated because,
Perhaps, but I'm looking at earning capacity. What does this woman have the ability to make?
in the record, you'll see that she can make off of oil and gas at least $100,000 a year. You will have evidence in
I
there.
thought the court found it was like $4,000 a month.
The trial court did find that it was at least that.
Well, there's a big difference between $48,000 and $100,000.
I agree with Your Honor completely. But he did say in paragraph 98 that it's at least the $4,000. And that's what he said it on. I believe he was giving a benefit to wife of that lower amount. But there is there's multiple things Your Honor can look at in the record that we cited in our brief, multiple ways to calculate wife's income where she makes significantly more off of the oil and gas.
So, and that's my question. What is it that's in the record that we can look to if we're trying to establish her earning capacity?
The 1006 summary that we introduced at trial of the most recent year of oil and gas money that we could get out of wife and discovery.
Which is not consistent with what the trial court found.
It is not, but the trial court didn't say, and I understand that there wasn't an exact ruling, and that's why I keep bringing up the at least that I think left the door open.
I understand it said
Okay.
at least, but right now, for purposes of discussion, I'm looking at the $4,000 figure it found. And I'm looking for anything else that we can look to if we are trying to establish earning capacity.
It's in the record and it's in the proof. It is not, I cannot point to you in the final decree where a ruling was made on earning capacity beyond that at least that I've quoted, and I think Your Honor's heard me quote that enough. But there isn't something in the final decree I can point to. There is plenty in the record that was introduced.
Okay.
Are 1099s issued for the oil and gas royalties?
Sometimes, we received some, not all. We had to trace bank deposits, printouts that we would just get from wife that she alleged came from the trust attorney. Sometimes we did get 1099, so it was a smattering of different forms of evidence that we used to create this.
And that 1099 would show what amount was paid to her for that particular year, right?
Yes, sir.
And did you receive a 1099 indicating that she received in excess of $100,000 for a particular year?
Not 110, it came from multiple different places, so I should have been more clear about that. It's not like oil and gas royalties are all coming out of one company. There's Wildfire, there's E-Energy, there's multiple different partnerships that the family trust had gotten involved in that they were selling to that would then create these. So sometimes we would get one, sometimes we wouldn't get any, sometimes we would get another one that showed a lesser amount. So we had a bunch of pieces that we were trying to put together. We had to use bank statements to fill in deposits that came in and actually get some information from the family trust itself to try to actually identify all this.
Did the husband put on any proof to show that the wife is not experiencing chronic back pain because of this lumbar fusion?
Yes, sir. And I'd go back to Judge Smith's, the answer I gave to Judge Smith's question. After this alleged back injury, after the lumbar fusion and all that stuff, that's when she then started all of the house flipping, and she testified to a laundry list that's been cited in the brief and is in the proof that was given at trial of all of the manual labor she did after the fact. The lumbar fusion not working and it being the preventing her from not being able to actually work only came up at trial. She didn't assert that throughout discovery. She didn't assert that in her deposition. So she only brings that up in trial, and that was to refute and downplay that she said she's not going to work because it's more fun not to work, stay at home, and smoke pot on a daily basis. Once she admitted that in the deposition, we made it very clear that she needs to go out and work, brought that argument to the trial court when it was appropriate. They knew where we were going with that argument, and then that's when the back pain all of a sudden got tied to the marijuana use and that she was in pain and incapable of working. That came up late at trial, but that's not the way it worked in discovery, and that's not the ultimate proof that she had to admit to on the stand during cross-examination.
Okay.
And I'd love to keep going, but I've got 3 seconds, which isn't enough time for me to get into anything.
Well, I have a question about the attorney's fees that were paid from, Mr. Libby argued that your client's fees were paid from marital assets as opposed to his client. So if you could briefly address that.
Okay. Yes, ma'am. So wife says I spent about $29,500 in separate property on attorney's fees during the course of the divorce. Husband then at trial says I've got $26,500 in attorney's fees on credit cards. So when we're looking at the marital estate, take out $26,500 from the marital estate and award that to me as separate property. The trial court agreed with that argument, thus creating a basic wash. Then the trial court, and attorney's fees are within the sound discretion of the trial court under Irwin versus Irwin. And we would say that the multiple illogical and irrational positions taken by wife throughout this litigation, she shouldn't be awarded with attorney's fees. And some of those are, the $40,000 rug is a prime example of that. While my client was out of the house, had no knowledge of what wife was buying and putting in the house, she purchased this rug. She never identified it in discovery. We found out about it at trial when during direct examination from her attorney, she said that she has a rug that's worth $40,000.
Well, didn't she pay $1,200 for that rug?
She did pay $1,200, but she testified that she bought it at an estate sale. So she didn't go to first they tried to say that she went to Costco and bought it. It wasn't purchased at Costco. It was purchased with a Costco credit card at an estate sale. She testified about how she goes to an estate sale and finds these things, and the reason she spent the $1,200 was because it is worth $40,000, and that's what she's going to have it insured for, and that's what the actual worth is of this, and that is one of the other ways that she goes about making more money. And then she tells the trial court, basically, I lied on the stand about the value, don't actually tag me with $40,000. Another illogical issue, unless Your Honor wants me to stop, I know I'm over.
I'm getting eyes from.
Okay, and I apologize.
The finding that the wife is economically disadvantaged, should that be used to perhaps justify an award of alimony in futuro rather than this transitional alimony for 4 years?
If the goal is to continue to have a citizen of this state that is not self-sufficient and is actively and apathetically maintaining being non-self-sufficient, then possibly. But all that this member of our society is doing, although capable of working, is sitting in a house every day, smoking marijuana on a daily basis, refusing to work, and now has 2 adult children that the proof also shows did not go to college, just got out of high school, are sitting at home with no jobs. So if we want to continue, and I don't believe that's the goal in the legislative preference, I think what we're looking to do is make self-sufficient members of society, then she needs to be on transitional alimony and simply get a job along with the range that she receives in her oil and gas money, along with this transitional alimony, which would transition her to that point of becoming a self-sufficient and productive member of society, rather than just sitting at home and doing nothing with her life.
All right, thank you.
Yes, sir. Thank you.
I think you've got 3 minutes for rebuttal, Mr. Leonard.
I'll first take offense that staying at home, raising children, and running a household is not being a productive member of society. I just disagree with that. I do want to respond to a couple of things very briefly that he just brought up. We got to argue the facts, but we can't bring in facts that weren't true. They keep saying that the wife didn't bring up her physical ailments until trial, and then Your Honor, I think, asked whether the husband acknowledged that she had ongoing problems, and they said no, that she just brought it up at trial. This is all the husband's testimony. Wife had a very long-standing problem with her back, was treated by multiple specialists, and had a spinal fusion in 2012. That's a trial transcript, page 358. Husband testified wife has chronic pain, abdominal pain, and migraines, in addition to anxiety and depression. Husband's claim that wife's physical issues were first brought up at trial is totally false. And husband acknowledged on page 216 of the transcript that she used marijuana for pain, anxiety, and sleep following her lumbar fusion. So to make it sound like she just brought this up and it never was an issue is completely untrue. The husband helped her with this condition. The husband did not discourage her from using marijuana. He's a doctor. It's been used, to treat her pain. Very briefly, page 96, y'all kept asking questions, and he kept giving answers of the court found at least $4,000. The paragraph 96 says wife earns approximately $4,067 per month from the oil and gas royalties she inherited from her parents and resides in the marital residence with the children. There was no finding of at least that. They keep adding in, again, the wife was getting these oil and gas royalties, but she also got some inheritance payments that are not considered income, that she got 4 large lump sums. They're summarized in both my brief and my reply brief. That was not, to make it sound like she has regular ongoing income that could increase, that's just false. We spent so much time on that issue and the court made its findings. With regard to the alimony, again, the court did not look at how much of a surplus the husband has. The husband has an $8,000 surplus each month. The court said he was concerned to order more alimony because it would make the court said if he ordered him to pay the full deficit of the wife, his financial situation to cover his own needs would be dire. Again, the judge allowed them to get away with saying, I'm going to have $5,200 in attorney's fees every month for the rest of my life. That the husband said at trial, I've never funded my retirement account. The whole $400,000 in the retirement account came from employer contributions, but I'm going to start putting in $700 a month. He was doing everything he could to reduce his surplus so she would get less arrearage. Allocation of debt. They've acknowledged that he has at least a $2,000 surplus. We maintain if you add in the retirement of $700 that he's funding and the $5,200 in attorney's fees, he has more than enough money to support this wife of over 25 years who raised his children, even though that seems to be of no significance to him. If I could just say 2 comments on the attorney's fees. All the statutes say you gotta apply 36.5.121. The court applied 36.5.103. It applied the wrong statute, it applied the wrong analysis, and Hufflin, Gonsecki, those are both Tennessee cases, both say you gotta apply 121. And then, again, we talked about the marital funds. When Mr. Rice said it was just not accurate, he tried to say that he was assessed with $27,000 on credit cards, and my client paid $25,000, so it's a wash. Well, what's totally ignored about that is my client has $51,000 in attorney's fees that were unpaid that have to be paid out of her separate property. She was given no monetary, she was given less than $3,000 from the trial in liquid funds. She has no money to pay attorney's fees. And to make it sound like, because he paid $80,000 out of marital funds, and my client has to pay $50,000 more out of separate funds, that's some kind of wash. That's not a wash. I mean, and I've cited case law where they said that's a dissipation of assets. My client should be getting not only her attorney's fees of $82,000, but she should get a portion of what the husband paid out of marital funds, because if the court's gonna they tried to 50-50 divide the assets and the debt, well, allowing him to pay $100,000 in attorney's fees and then say, well, that was out of marital property, but we're gonna say each side pays their own, well, it's totally frustrated that purpose, because he's paying it out of their money, she's paying it out of her money. I would highly direct y'all to my brief and my reply brief. We've tried to address the other issues, and we would again, do I have more time? Or that far over?
About 3 minutes ago.
Okay. Oh, it says at 1:44. It's like, wait a minute.
No, it's going the other way.
But thank y'all very much, and we would ask that this matter be reversed and sent back down for a new trial, unless your honors are able to craft out a ruling from it. Thank you, your honors. Good seeing y'all.
Thank you. Thank you, counsel. We will take this matter under advisement and try to get you an opinion at the earliest possible time.